every person who is charged with a criminal offense is entitled to defend himself in person or by a legal practitioner of his own choice.
Remember that an individual is entitled to remain silent.
Every citizen in Nigeria is entitled to maintain a private life.
You are approaching a military checkpoint or a police checkpoint without knowing that it's against or it offends them and subject you to a frog jump. That is wrong.
Hello out there, you are welcome to another fresh episode of the program Justifying Nigeria on ACNN television, reaching you from Abuja. On today's episode, we are going to be looking at the topic that says the legal essence of power of an attorney. My name is Anozie Chinomso. In a world that is full of dynamics and changes, there are certain things one wishes to do, but because of certain circumstances beyond his or her control, that may not be done. For example, where one is abroad and wishes to carry out a transaction on his or her property or properties here in Nigeria, he may not be able to conveniently carry out that transaction because of distance involved. It is interesting, therefore, to underscore that the law has provided certain legal instruments and procedure to sort out issues like that. One of them is power of attorney. This is an instrument in writing usually, but not necessarily by deed, by which the principal, called donor, appoints an agent called donee and confers authority on him to perform certain specified acts or kinds of acts on behalf of the principal, having established these facts. Certain issues seem to arise. What is power of attorney in its entirety? Who then is an attorney? Who has the capacity to appoint an attorney? What is the legal essence of power of attorney? With me in the studio to address all these issues is Kelechi Nwokogo Esquire. He is a legal practitioner and legislative consultant here in Abuja. You're welcome to the program, sir.
Thank you for having me.
Thank you very much. You are here again.
It's my pleasure and honor to be here once again.
Thank you. So let's get talking. What is power of attorney? And can there be two attorneys appointed by the same instrument? First of all, what is power of attorney based on legal perspective and to the understanding of our viewers?
Okay, thank you. Power of attorney can be said to be a legal document which may be under seal. Okay. It may be under seal that allows an individual or a person to appoint another as another person who may be referred to as a donee, and the person making the appointment referred to as the donor. The appointment is made to enable the party who is being appointed to be able to carry out functions or responsibility that ordinarily the person who is so appointing could have been able to carry out by himself or herself. So it is a legal document that enables an individual to appoint another person to act in his stead on his capacity over, it could be to take care of properties or financial responsibilities, or to even institute cases in courts on behalf of the person who is so appointing.
So that's what the power of attorney is. It's a legal instrument.
It's a legal instrument.
Now, from your explanation, can you use the scenario to paint it so that our viewers that are non-lawyers will understand? For example, you own a property.
Yeah.
You can appoint maybe somebody or Mr. B to act on your behalf. So that Mr. B can now communicate to Mr. C on your behalf. And whatever thing they are doing is on your behalf. That's what you're talking about.
That's what I mean. We are a situation where, like you've clearly stated, a situation where Mr. Okeke is appointing Mr. Adamu to act on his behalf, maybe because of incapacitation, or maybe because of distance issues, depending on where the particular person is at that point in time. So where he is unable to carry out these responsibilities ordinarily, really, you know, such person could have carried out by himself. By way of power of attorney, a person can be appointed to take up these responsibilities on behalf of the donor. And whatever action that comes out of this appointment by the donor, you know, to the donee, it's legal.
It's legal.
And stands.
All right. How can it be created? Because when we are talking about instrument, legal documents, how can it be created? You just wake up one morning and you say you want power of attorney. How can it be created? What are the procedure, the process it takes?
Okay. To create a power of attorney, the person so creating must first of all have both the mental and the legal capacity to create such a power of attorney. The legal capacity, in the sense that the person must be of legal age, which is of course is 18 years and
According
above.
to Constitution.
Yes, and again, the person must have the mental capacity, as at the time the power of attorney is being created, he must be of sound mind. He must be a person of sound mind. He must be mentally stable, so as to be able to know the instructions which he or she is giving. So first of all, the person must be of legal and must have the legal and mental capacity to create. And again, the person must find out, be able to identify who he or she is is interested in appointing as his attorney. You must be able to identify who you want to be your attorney. And like I've said earlier, in appointing any person as an attorney, as a representative, the person so appointed must make sure that such person that is being appointed is a person of a stable character. He must be a person who is trustworthy, who can be able to carry out such responsibilities, and of course who is experienced in that particular area or field. Such person must also be a person who has the capacity to make documentations for future references. So it is important that all these things are being considered. And again, in creating a power of attorney, it is also important that the true intendment of the donor is properly captured. The true intentions of the donor must be captured as he wants it. The donor may not want a situation. It will not be okay for a person who is, of course, drafting a power of attorney for an individual or a person who wants to create such agency relationship, you know, to begin to create problems for the donor or for the client by misrepresenting the intentions of such a person. So it is important that the actual and true intentions of the donor is properly captured at any time such a power of attorney is being created. And again, it is also important that in creating a power of attorney, that such legal document or legal instrument is properly signed by the various parties. Like we said, the parties are known as the donor or the donee. And again, it is also important that after the signing of the document, is also expected that the document or the legal instrument is being witnessed by at least 2 or more persons. So these are ways through which such legal document or legal instruments can be created.
What happens when the documents are not signed or is not witnessed by 2 or more persons? These and more we are going to find out from Barrister Kelechi after we come back from break. Please do join us again. Hi, you're welcome to another episode of The Speaker on ACNN Television. On today's episode, we are going to be asking a very important question to all Africans on whether we are cursed or we are the curse.
My name is Anozie Chinomso. When I look at Africa, and I look at her often, when I imagine about Africa, and I imagine about her often, certain questions comes to mind. Why has Africa not realized her potentials? Why are the 55 countries of Africa still referred to as developing nations? Over the years, Africans have been commodified. It started with the Arabs, when Africans were first enslaved. Then came the Europeans, the Portuguese, the Spaniards, the Germans, the French, the Belgians. Africa became the hunting ground for European colonizers. When slavery has lost its potency, the Europeans abolished it and replaced it with another pernicious enterprise called the colonization of Africa. Beyond all this, it was a divine establishment that man was made out of the soil. And the last time I checked, the soil was black or brown and not white. And therefore I suspect that an African was the first creation by God. And as such, we have an edge over other civilizations and colonial masters. But with high level of complacency and political stagnation in all the African countries, I'm persuaded to ask on whether Africans are cursed or we are the cause. Ourselves, because this is a message to Africa. Why must Africa keep on producing leaders who so much believe and depend in the Western civilization? We are the richest continent on earth, yet ironically at once we are the poorest continent on earth. With all the mineral and natural resources, Africans are still dying in hunger. Go to Johannesburg, South Africa. There is gold here. In fact, the native name of Johannesburg is Igoli, which means gold. Go to Ghana and Cote d'Ivoire. You will see cocoa. Go to Namibia, Lesotho, and Botswana. There is diamond there. Go to Zimbabwe. You will see uranium. Go to Zambia. You will see copper. Go to Equatorial Guinea. You will meet oil. Go to Angola. You will see oil. Go to Uganda. You will see oil. Go to Gabon. You will see oil. Go to Benin. You will see oil. Go to Cameroon. You will see oil. Come back to Nigeria here. That is where you will be confronted with a natural special oil. Go to eastern part of Africa in Kenya. You will see tea and coffee. And yet, an average rural African feeds below $1 a day. Africa, are we cursed or are we the cause? How can it be that Africa is the richest continent on the earth, and our gold is mined by the bears, and the price of our diamond is determined in Belgium? How can it be that Africa is the richest continent on earth, and our oil is mined and excavated by Shell, BP, and Total? How can it be that Africa produces cocoa and chocolate is made in Switzerland and Belgium? How can it be that tea is produced in Ethiopia and is taken to the United Kingdom and is called an English tea? How can it be that cotton and rare earth is mined in Democratic Republic of Congo and not a single African country produces their mobile food? How can it be? How can it be? How can it be? It can only be because our leaders have allowed their minds to be captured and conquered by the Western civilization. It can only be because we have allowed ourselves to be spiritually confused. It can only be because our political leaders have allowed themselves to be slaves to foreign leaders. And the God we worship, knowing that we are confused, has turned his face away from us, so that when we pray and fast, he refused to listen. Or if he listens, he does not answer us. He's waiting for us to realize ourselves so that we can worship him in truth, spirit, and honest labor. Fellow Africans, it's high time we began to decolonize our minds. This is because the mind is the standard of the man. All battles are first of all fought in the mind. René Descartes was right when he said, and I quote, cogito ergo sum, unquote. I think, so I am. And therefore we must think. Our leaders must think. Because once our minds are changed, our initiative and manpower is energized. And when they're energized, then we exercise the ghost of low self-esteem. And once we do that, we begin to recover our potentials as Africans. Then our economy begins to grow, and we mine our gold, oil and copper, and diamond, and improve them. It is true that Africa is the only continent that is so generous in welcoming and accommodating all the civilization in the world. We started with the Arabs. They dealt with us. We accommodated the Portuguese. They dealt with us. The Dutch came. We accommodated them, and they dealt with us. We accommodated the French, and they dealt with us. We accommodated the English, and they dealt with us. We accommodated the Indians, and they dealt with us. We accommodated the Lebanese, and they dealt with us. Now we are accommodating the Chinese, and they are dealing with us. We must stop this. So today, the speaker is not here to speak a new thing. The speaker is only here to remind ourselves that in the beginning there was God. And that God created man. And that man, the speaker suspects, was an African. And that could not have been nobody or anything else than an African. The reason is because all creation said that man came from the soil. And as I've said earlier, the soil or earth is either black or brown and not white. So in the beginning there was an African. And in the beginning there was a spirit into which that mold became alive and came out of existence. And that spirit is God. I believe that God has given us intelligence. As such, let us use it wisely in order to make the best out of Africa. Africa can be great. Africa must be great because we are not cursed. I therefore speak that until the leadership of Africa, and indeed all Africans, begins to rise and spiritually and politically decolonize our minds, our hearts, and our culture by contributing our quota in doing that which is good and right, our generation and the ones yet unborn will continue to think that Africa is cursed or we are the curse ourselves. My name is Anozechi Nomso. I just want to speak.
Hello, glad to know that you are still there. We are still here with Barrister Kelechi Nwokogu. He's an Abuja-based legal practitioner and also a legislative consultant. Thank you, sir.
Thank you, sir.
Before we went for break, you established the fact that the parties involved, when we're talking about the parties, the donor now, maybe the owner of the property and the donee, whom you want to confer the authority or the power of, must sign. And of course, there will be witnesses. Suppose the parties, one of the parties did not sign. Maybe in this case, donor signs and donee did not sign, or donee signs and donor did not sign, and there is no witness. Will it vitiate the entire procedure, the entire instrument?
Of course. These are vital components, vital elements of a valid legal document, not just a power of attorney. For any document to be legally valid, such documents must be properly executed, and in executing these documents, such documents must be signed and they must be witnessed. So in this circumstance, it will definitely vitiate the provisions of the power of attorney, where such power of attorney is not signed by either of the parties or properly witnessed, as the case may be. Okay,
thank you very much. Now, in the issue of creating this legal document or power of attorney, can a corporate soul be seen as a donee? For example, I am in abroad, or because of my busy schedule, I decide to appoint maybe E&O estate surveyors to be my donee to take care of my property. Is it possible?
Yeah,
Well, that's what I mean by
it's very much possible. In appointing an attorney, it's not necessarily
must be an individual.
Yeah, it must not necessarily be an individual. A company, an agency can be appointed as an attorney on behalf of another. You know, such agency relationship can be created with a corporate institution, not just an individual.
An individual.
Not just an individual.
Okay, so maybe in a case where some group of people comes that they are representing somebody, of course they have the full authority to do so. Thank you very much.
Welcome.
Now, are there types of power of attorney? Oftentimes we hear revocable and irrevocable. Please, can you distinguish it? Let's know what it means for a better understanding of our viewers.
Okay. A power of attorney can be said to be revocable, where such power of attorney is revocable at the will of the donor. A power of attorney can be said to be revocable, where such power of attorney is revocable at the will of the donor. And
please,
yes.
bring it down at the will of the donor.
Yes.
Let's get to
yes.
yes.
What this means?
Yes.
What this means is that where a power of attorney is said to be revocable, such power of attorney can be revoked, you know, either expressly or impliedly or by the oppression of law by the donor himself, the person donating, you know, the power, such authority. For instance, where a person is given a responsibility, and it is also important at this point in time that I also make it clear that creation of a power of attorney does not deprive the donor the rights to also carry out functions on such powers that may have also been given out.
Even when the instrument is still subsisting, properly executed
yes,
and witnessed,
yes,
they can still.
It doesn't still deprive
the donor.
Yes, the donor the responsibility or the rights to still act on those.
Is it not usurping the power of the donee?
That is the position of the law.
Okay.
That's the position of the law. So where a particular responsibility has been vested on an individual to carry out as an agent or as attorney in an agency relationship, and the donor goes ahead to carry out such functions, such
even specified ones.
Specified ones.
It still stands?
Yes. So such now revokes the power of attorney that is in existence between the donee and the donor, because the donor has already carried out that function that has already been placed on the donee.
So that one, is it operation of law or implied?
That is implied revocation. Implied revocation. Now, express revocation is comes up where the donor expressly terminates the agency relationship between him.
How? Through writing or letter?
Of course. The donee must be communicated, and it must be in writing.
Okay.
The donee must be communicated in writing, informing him of the intentions of the donor to relieve him of such responsibilities. So now, by operation of law, a power of attorney can also be revoked, either as a result of bankruptcy or as a result of the death of the donor or the donee. So these are ways a power of attorney.
Three basic ways. One, implied revocation. And where the donor is carrying out some of the, in fact, the specified responsibility of the donee. You see yourself, for example, a donor says you should collect house rent, and you see the donor taking the house rent. Next year he does it. So impliedly. Okay, it's being revoked.
Yes, it's being
then
revoked.
Expressly, you explain that it must be communicated either through a lawyer or writing of letter to tell you that, please,
your services are no longer needed.
Or that
By
of operation of law, maybe in the death of the donor or bankruptcy of the donor.
So,
thank you so very much.
You're welcome.
Now,
you also talked about the irrevocable power of attorney.
Yes.
Where, like we said, there is revocable and irrevocable. Now, where it is irrevocable, what it means is that it is irrevocable even at the will of the donor. A power of attorney is irrevocable if it is irrevocable even at the will of the donor. And what this means is that where a donor has created an agency relationship with an individual, and it happens that such relationship or such agency relationship is for is for a consideration.
Okay, consideration like maybe monetary consideration.
Yeah, where there is a consideration over any power of attorney that is being created between a donor and a donee. Such power of attorney can be said to be irrevocable, even at the will of the donor.
That means the donor cannot come up tomorrow and say, please, I want to revoke it.
Yes, because there is consideration, covering that particular legal.
Can it be right under law to say that irrevocable power of attorney is somehow like a conveyance of interest?
Yeah, it's irrevocable.
Because from what you're explaining, if, for example, now maybe you say, so this is my land. Please, okay, I appoint you as my attorney, but just give me something. I say, how we say 2 million or 200,000. I give it to you, and there's irrevocable power of attorney. It means you can't wake up one day and say you are revoking it.
Of course, and that is why.
Do you understand? Yes, are you actually,
alienation?
Yes. Okay, maybe that's the proper language.
Yes.
Please explain it. Let's understand.
For some persons, it's been argued, just like in some jurisdictions, power of attorney is also used in transfer of title to land. Okay. So, and that's mostly irrevocable power of attorney because there is consideration. So where such relationship is being created for a valuable consideration to a reasonable extent, it also means alienation of that property. But ordinarily, a power of attorney does not confer ownership. It does not confer ownership. It does not confer possession
to the donee. Ordinarily.
It does not confer ownership. It does not confer. It is not alienation of property, of interest, of proprietary interest.
Okay.
But
once it becomes irrevocable.
Because and for a valuable consideration.
In just a minute, what is your advice to our viewers in case when they hear about power of attorney so that they will actually know what it is and how they can go about it?
Yes. My advice to the viewers, wonderful viewers, is to make sure that at any point in time that you are not empowered enough, or you are not in a good position to take care of any situation with respect to management of your property, or with respect to carrying out any financial responsibility or any function or responsibility at all. You are at liberty to appoint an attorney who will definitely serve as your representative, carrying out your instructions at your own best interest. So it is something that everybody must be inclined, must be willing to do. It does not, like we've said, it does not mean alienation of your proprietary interest or your ownership of the property. It does not give away the ownership of the property. It only allows your donee or your attorney to manage the property or whatever instruction you may have passed to him to your own best interest. And that is the only legal way to have a representative management of your properties when you are not available.
Power of attorney is one of the legal ways to have a legal representative to manage your property. Barrister Kelechi, I want to appreciate you for coming again.
Thank you.
And I know when we keep on calling you, you're obliging us.
It's always my pleasure.
Thank you very much.
It's my pleasure. Thank you.
It is a statement of fact that a power of attorney is useful for many purposes. It may be created to collect money on behalf of the donor, to prosecute a case in court, or any other wish of the donor. It is important to note that where the authority conferred on the donee empowers him to execute a deed, his appointment must be by deed. Also note that where two attorneys are appointed by the same instrument, it is necessary to show clearly whether the donor is to be bound only by the joint act of both or any one of the donees. And whether in the case of the death of one donee, the surviving donee has the power to continue to act. Finally, The power of attorney is construed strictly. Therefore, it is advised that when drafting a power of attorney, the powers of the donee must be listed exhaustively such that on fair construction of the whole instrument, the authority in question is provided either expressly or by necessary implication. This is where we draw the curtain on today's episode of Justify Nigeria. Join us same time, same station on another fresh episode of the program. Until then, this is Anozie Chinomso wishing you the very best and bye for now.